everyone. Thank you very much for joining us today for this webinar on advanced planning, which is going to cover topics such as wills, power of attorney, and representation agreements. My name is Laura Katawaki, and I'm a research and knowledge mobilization specialist with United Way BC. And I'm very happy to be the host for this webinar, as I think it is going to be so valuable for the community-based senior services sector. As I know often, of course, when you're working as a community connector or an information and referral volunteer or in other positions in the sector, there might be older adults who come to you and they have questions about these types of documents, or it seems like they would be useful for them. And so then being able to know more about them yourselves and also about different resources you can refer people to is really valuable. So hopefully everyone's going to learn a lot from this presentation. Before we get started, I did want to do a land acknowledgement. So United Way BC acknowledges the homelands of the Indigenous peoples on this place we now call Canada and honors the many territorial keepers of the lands on which we work. I myself today am working from the traditional, ancestral, and unceded territories of the Coquitlam First Nation. And I thank the Coquitlam who continue to live on these lands and care for them, along with the waters and all that is above and below. And I'd encourage you in the chat to introduce yourself and also to acknowledge the territories that you're joining us from. A few housekeeping notes before we get started. So during the presentation, everyone is going to be muted. Feel free though, as I mentioned, to introduce yourself in the chat box if you'd like. You also can turn on the closed captioning feature using the CC button at the bottom of your Zoom toolbar if you'd like to have closed captioning. There's also going to be a Q&A period, and we've actually decided that after we discuss each type of document or tool, we'll have a little pause for questions. So if you want to ask anything, for example, about representation agreements, after we finish talking about that section, we'll have a pause so you can ask any questions that are at the forefront of your mind. So feel free to put them in the Q&A box or also to put them in the chat as well. And then finally, the webinar is going to be recorded and it'll be posted on Healthy Aging Core, and also the slides will be made available. So now I have the pleasure of introducing our presenter, Marie-Noelle Campbell, who is an executive director and lawyer for Seniors First BC. Marie-Noelle was called to the bar in New York State and British Columbia, and she started her legal career in Canada at a pro bono organization where she launched and managed programs to represent clients before various tribunals. She was later appointed as an adjudicator for the Mental Health Review Board, and then opened her own law firm, focusing primarily on immigration and refugee law, and also housing law. She's now honored to serve older British Columbians in BC, along with Seniors First dedicated team. And I've included a screenshot of the Seniors First BC website here, because I really encourage you, if you haven't already checked out their website and their services, to go visit it, as there's a lot of really great information and resources as well. And I know Marie-Noelle will talk a little bit about that at the beginning of her presentation. So without further ado then, I'm going to hand it over to our presenter.
Thank you very much, Laura. And I want to acknowledge that I'm joining today from the traditional, ancestral, and unceded territory of the Katzie First Nation, but later I'll be going to Vancouver, and our organization, as a provincial organization, works on the traditional territories of over 200 First Nations. So we want to acknowledge all of them. Okay, I'm going to share my slides now. Just a second. Here we go. So we have a bit of a disclaimer. This is just for information purposes. Please do not use that as advice for any of the clients or people that you serve. We recommend that individuals seek legal advice, and if you think that the clients that you serve qualify, we encourage them to call our Seniors Abuse and Information line at the number below, or email us if they have accessibility issues. So I'll provide you a brief introduction to Seniors First BC. So we are a 31-year-old nonprofit organization and charity. We provide information, legal advocacy, and support for older adults across BC with issues affecting their well-being. We have 4 main departments. The first one is the Seniors Abuse and Information Line that we refer to as SAIL. It's a confidential information referral helpline, a safe place to speak about concerns of abuse and neglect, and the entry point to access all of our services. It's available every day of the week from 8 a.m. to 8 p.m., except on statutory holidays. And if someone needs language interpretation, they can start the call by saying the language that they need help with. So they could start the call and say Punjabi or Mandarin. And for people who are deaf or hard of hearing, they or have other accessibility issues, again, they can use the email. So when our SAIL intake workers hear about situation of severe abuse, they refer them to our victim services program that can focus on safety planning, explain how the criminal justice works. Many of our clients are afraid to contact police, and that's the opportunity to go about what it would look like if they did and understand how that would work. And then they can decide for themselves what they want to do. Our public education and outreach program provides learning events, usually to the public, but we also have events for community partners like this one. We have many others on elder abuse, on frauds and scams, government benefits, tenancy law, and so forth. And we offer them in person and virtually. So if you think you or anyone you assist will be interested, I invite you to check our website or request a presentation. We also have a guide on navigating home care and senior housing. It's available on our website. When it comes to our legal services, I won't go into each particular program, but we have a few that provide assistance about general issues that affect older adults, from basic summary advice to full representation in court, including drafting legal documents such as wills and powers of attorney and representation agreements. The documents we'll refer to over the course of this presentation. There's many other issues, so evictions, debt issues, identity theft, appealing a decision for government benefits, discrimination about age, and other elder abuse topics such as revoking a power of attorney or a committeeship application when someone does not have anything in place and they have lost capacity. Their loved ones may want to need help applying in court to be able to become committee, which is a type of guardianship. However, we do not assist with family law or criminal law issues. Our services, our legal services, have age and income and asset criteria. For all the other services, it's just about the age of the older adult. So anyone who's concerned about the well-being of an older adult can call SAIL and our victim services program or request a presentation. When it comes to legal services, though, because we are an organization that serves people who are lower income and we're a charity, we cannot assist all those who need help, but need to triage based on income. So the criteria are on the slides and you will get them. Just so you know, when it comes to people who live on First Nation lands, like as First Nations or on reserve lands, the asset test does not include their primary home on reserve or equivalent land. I hesitate to say on First Nation land because all of BC is on First Nation land. So I'm really talking about people who are status under the Indian Act. I understand that this act is outdated, but this is just how the system works at the moment. So we have elder law clinic locations at our office. We have a monthly clinic in partnership with community for people who identify as Two-Spirit, LGBTQIA+, in other locations in the Lower Mainland. And for advanced planning clinics, these are clinics that focus only on wills, powers of attorney, and representation agreements. And we have many locations. I saw that someone was joining from Seychelles. We have actually two clinics in Seychelles, one in partnership with the Sunshine Coast Resource Center, and that's for the general population. And we also have an MOU with the Seychelles First Nation, and that's exclusively for members of that nation. However, we have other community clinics on an ad hoc basis. And the way it works is we have wait lists for each location. And whenever there are enough people to warrant a trip, we call anyone who's on that wait list or in the vicinity and invite them to attend the clinic. So we have some in Bella Coola, Bella Bella, Haida Gwaii, and many other locations. So all of that is, all of those intakes are done through SAIL. So now I'm going to get into the core presentation and go over each instrument as mentioned by Laura at the beginning, because there's so many types of documents. I will pause after reviewing each type of document and invite you to ask me questions about that document, knowing that we'll talk about the other ones afterwards. So understanding is really about incapacity planning. It helps ensure that your loved ones can help you with your finances and healthcare when you need it. So while you're alive, you may need a representation agreement, a power of attorney, an advance directive, or you can talk about joint ownership. It's important to know that those documents are only effective when you or anyone you serve is alive. There are so many people who believe that they have everything in place because they have a power of attorney, and it does not work when they die. The minute they die, the document ceases to be effective. That's really important to know. And it's the same for all the documents listed here, except for joint ownership, but I'll go over that a bit later. Estate planning ensures that your wishes will be respected after you pass. It reduces unnecessary expenses and prevents disputes among family members. And that's important even for people who are low income. We see issues about funeral wishes and belongings, and who should take care of that. So it's just so much easier when someone has everything in place. So after you die, the will is the document that will give the instructions about what should happen to what you have and your body. And joint ownership may be helpful, but it may also work against the primary joint account or joint account holder or joint owner. So I will go over those distinctions and why it's important to really think about that before setting it up. And whenever people come to us, we do a capacity assessment, but we often hear loved ones saying, my mother or father has dementia and they're not capable of managing their finances. And it's really important to know that we always check whether the person is capable at the time we meet with them. And we understand that capacity may fluctuate. So people may receive medications that make them more dizzy or be less functioning during the day or at different times of the week. Sometimes they start a new treatment. So it's really a spectrum, and we do not assume that someone is incapable just because they have a diagnosis. And we encourage people to get a diagnosis early. Treatments are improving, and current treatment may help prolong someone's capacity over time. So basically, an adult is presumed to have capacity by law, but people can challenge their level of capacity, and medical evidence and a court order can result in you or a loved one or someone you serve in losing control of their decision-making authority and finances. And that will be the example of a committeeship application. But that requires affidavits from two doctors explaining why that person is incapable of managing their finances. So it's not just based on a diagnosis. It really requires more investigation into why that person is not able to take care of themselves, or to which degree. So the first tool is the representation agreement. And there are many forms of it, but generally, a representation agreement is a legal document signed by the adults in front of witnesses, which appoints one or more people, the representative or joint representatives, to make healthcare or personal care decisions on their behalf. Some representation agreements also allow to make financial decisions, but they are more limited in scope, and I will go over that shortly. A representation agreement can be revoked as long as the adult is capable. So the most general representation agreement, we say that is the most general, is the extended representation agreement, covers only healthcare. And the reason why is typically if someone has full capacity to make healthcare and financial decisions, they will have a Section 9 representation agreement, which is the broadest type of representation agreement to make healthcare decisions, and they will have a power of attorney to appoint someone to assist them with financial decisions. There's another type of representation agreement that focuses on limited healthcare decisions and financial decisions, but that's really just for people who have diminished capacity. So the Section 9 representation agreement, along with the power of attorney, is the golden combo, so to speak. So the representation agreement for healthcare decisions only, Section 9, can include all major and minor healthcare and personal care decisions, like surgery, day-to-day decisions. It can give the representative certain additional powers, and that these would have to be listed. But that would also be the document used when someone enters long-term care. That's the person who can decide what the treatment plan should be, who should have visitation rights, what kind of diet the adult should have, what type of spiritual habits they have, and discuss that with the treatment team. It is important to know that the healthcare team always needs to check if the adult is competent in making those healthcare decisions that will be necessary to take care of them before consulting with the representative. So even if someone has a representation agreement naming their, let's say, daughter, it doesn't mean that the daughter can immediately decide what their parents should do, what type of care they should receive. It is only the case once they have lost capacity. But as long as the adult is capable, the healthcare team must check with the adult first if they can make that decision for themselves. However, the adult can require to have their representative present to make those decisions, and the representative may assist the older adult or the adult generally in making those decisions, and they can request health records, for example. They can have conversations with a doctor and then assist their loved one, the adult, in making those decisions. And as long as the adult is capable, the adult, being the person granting the representation agreement, will have the last say. It's only when that person is no longer capable of making those decisions that the representative will be the one making those decisions on behalf of the adults. A Section 7 representation agreement, like I said earlier, is really for people who have limited capacity. And that's to assist with the routine management of their financial affairs, legal affairs, and healthcare decisions. It's typically not enough to move into long-term care or assisted living facilities. So despite, their legal duties, a representative needs to act in good faith, having in mind what the adult they represent would have wanted for themselves. Um, Representatives may still consent to treatments that the adult would not have wanted. Um, it's not right, but there is that opportunity to do something wrong. They may also unreasonably restrict visitors or social activities, which is why it's so important when someone decides who should represent them that they pick someone who's going to be on the same page as them when it comes to who should be allowed to visit them, what they want, and and if there's any doubt, to also put that in writing in the representation agreement. I wish for all of my children, for example, to visit me, or I don't want so and so to visit me. Um, there are there are so many ways to tailor a representation agreement to that adult to ensure that it serves them right. But picking the right representative is crucial. So the adult should choose someone who understands and respects their values, even if there's some conflict with how the representative feels about those choices. There's wishes and beliefs. For example, organ donation. Even if someone is a registered organ donor, it's helpful for the representative to know that it's the case. Spiritual beliefs, whether the representative is spiritual or not, and same for the adult, will the representative honor the wishes of the adult? It's good to pick a representative who's available locally and who's knowledgeable about the healthcare and the health needs of the person they represent. And it's important to pick someone who the adult feels comfortable having access to, all those records, which can be really intimate records when you think about what can happen when someone is hospitalized or goes to long-term care. And on this note, there could be a representative who assists temporarily because someone is, hospitalized, like I just said, and the adult is just temporarily incapable of making decisions. But then once they regain consciousness and after some time, the adult may be, fully competent again and able to make their own decisions. And that's a bit different from how the power of attorney can work. Any questions on this before I move to the next type of document? So it's a bit difficult for me to see the chat, so I'm going to ask Laura to let me know.
Nope, there aren't any on the representation agreement.
Okay. So an advance directive is a document when someone can put written instructions, giving or refusing consent to healthcare treatments, provide instruction about what should happen if, they have a terminal illness, who should be by their bedside, what they want. Usually it's needed when someone does not have a representative. So if someone has a representative, that's, like I said earlier, it's the golden standard. If they don't have anyone, then an advance directive is the next best thing. And there can be also so many conversations with doctors. Some people have most. I don't go into all the options, but that's really what the advance directive is for. It used to be, and I think it's still called in Alberta, a living will. Just so you know, it's the same thing. Now, powers of attorney. So power of attorney is a written legal document signed by the adult, so the person who grants that document, who appoints one or more people to make financial decisions on the adult's behalf. The adult and the named attorney, again, it's a bit of a confusing term. The attorney does not have to be a lawyer at all. It's just an attorney under a power of attorney, someone who's appointed to make decisions under that power of attorney. And each of them must sign in front of witnesses. Some banks require everybody's signature to be witnessed by lawyers. However, it's not what the legislation requires, and we are talking to the Office of the Seniors Advocate and various financial institutions about that, because it can be a huge barrier in small and rural communities when there's just not that many lawyers. Sometimes there's just one, or they're just so far away. And if there's just one and people had a family dispute, that lawyer might be conflicted. So anyway, under the legislation, the adult signature and the attorney signature needs to be witnessed by one lawyer or notary or two non-lawyers who are unrelated to them. But we advise people to consult with their bank to see what they require to make sure that the document would be valid if their attorney signatures are not witnessed by lawyers. It can be revoked as long as the adult is capable. So it can be used for financial decisions, business decisions, banking, managing property, and limited legal decisions. It could be, to represent someone before the residential tenancy branch or to hire a lawyer. It does not apply to healthcare and personal care matters, which is why if someone enters long-term care, the facility typically requires a power of attorney who's going to decide how the contract will be paid and the fees will be paid, and the representation agreement will be needed to make sure that whoever has authority to make decisions about where the person should live is also a signatory to the contract. It can be the same person who's named as representative and attorney. It doesn't have to be, but it could be. There are a few types of powers of attorney. The most common one is a general enduring power of attorney, which means that as soon as the adult signs in front of a or multiple witnesses, depending of if they're a lawyer or not, or notary, and the attorney signs, then it's effective. When that happens, both the adult who granted that document and the attorney can make decisions on behalf of the adult. No one is required to check whether the adult is competent, unlike the representation agreement. If you recall, for the representation agreement, the healthcare team has a duty to check whether the adult is capable, regardless of the existence of a representation agreement. With the power of attorney, whoever has that power of attorney, the attorney, if they present a properly executed document, there's no requirement to check whether the adult who granted it is still able to manage their affairs. And it continues past the point of incapability. So when the adult is capable, they can make decisions about their banking and properties and finances and so forth, and the attorney can do that. When the adult becomes incapable of managing their affairs, then only their attorney can make those decisions on their behalf. And they can name one attorney, they can have joint attorneys, or they can have alternate attorneys. So one main attorney, and if that person can no longer do it, then the second one would be able to step in. There can be issues with joint powers of attorney, joint attorneys, by the way. Do they agree on everything? Are they local? How complicated is it going to be to get both signatures? So these are considerations when making a power of attorney. We ask, who do you trust? And a few people want to have, both of the kids, all of the kids together, and that can be quite cumbersome. Generally, if you trust one person to do it, maybe that person who's the best with managing finances could be the primary one, and then the second one could assist if the first one can do it. But again, I'm not giving general legal advice here, it's just legal information. People should just think about all of this so they can make an informed decision about who they should appoint and what the document is for. And then maybe in some cases, joint attorneys are the way to go. So I went over the general enduring power of attorney. Now, a power of attorney could be a springing power of attorney. So it starts the same, everybody signs, but it's not effective immediately. It's dormant until something happens. So most typically, the limitation, the triggering event would be a report from a physician stating that the adult is no longer capable of managing their affairs. Or it could be two physicians attesting to the fact that the adult is no longer capable of managing their affairs. When that happens, then the attorney is able to make decisions on behalf of the adult. But until that happens, the power of attorney is not effective. It could be just for a trip. Let's say you're going to Mexico for 2 months, and the attorney is only going to be able to make decisions from February 20th until 2 months later. So at the end of April, the attorney can no longer make decisions, and he or she or they can't make decisions until February 20th. Some people really like that because they don't want their children or loved one to mingle too much. And some just prefer to have, their children or neighbor or whoever they really trust to make those decisions immediately. There are additional considerations with that. For example, if someone has physical impairments or a disability or multiple disabilities, the attorney who's given a power of attorney under a springing power of attorney will not be able to go to the bank, represent them until they are incapable. But this is about mental capacity. So if a client tells me that they want a spring power of attorney so that their attorney can only assist them when they are no longer mentally capable of managing their affairs, it might be a problem if they have mobility issues and they wish their attorney could go to the bank, or especially in rural areas where, for example, I mentioned Beacola, where the place to bank is Williams Lake most of the time. There's a credit union there, but many people do their banking and all of their business in Williams Lake. Well, that child with a power of attorney will not be able to assist mom if she only has mobility issues, if the spring power of attorney states that it's only effective when one or two physicians provide an incapability statement and state that they're no longer capable of managing their affairs. So that's why it's really important to pick someone that they trust. And if they fully trust that person, can that person have a general power of attorney? Because the spring power of attorney may not be helpful if they really want someone to physically go to an institution to or to sell their car or to help them with other affairs or decisions, and they just don't want to physically go somewhere. I hope that makes sense. So now when it comes to the authority given, it can be a general power of attorney. So anything that I have, my attorney can help me with, or it can be very specific. I only want my attorney to help me with the sale of my home or with the sale of my car. Or I only want my attorney to help me with my tenancy, my residential tenancy agreement and issues that are related to that. So it's up to the adult to decide the scope of the power of attorney. Now, I wanted to quickly mention bank powers of attorney because sometimes bank will ask that their clients sign a bank power of attorney. Just one word of caution: if someone has a general power of attorney and then signs a bank power of attorney, typically the bank power of attorney will have a clause saying that I revoke all prior powers of attorney. So by signing the bank power of attorney, they invalidate the general one. So there can be a conflict between powers of attorney. Now it may only come to light once institutions are made aware of those two powers of attorney, but I just wanted to flag that issue. So we see a lot of issues with powers of attorney not being used properly. So attorneys who help themselves, to their parents' funds, they buy a car, say, well, it was to help mom or dad with grocery shopping, but when you look at it, it looks like they're really using it for their own benefit, or they start getting their own groceries using their parents' bank accounts, or they sell their parents' property. So again, it's not allowed, but once that power of attorney is signed and duly executed, there's immense opportunity for elder abuse. And that's why it's so important, again, to choose someone that the adult completely trusts to make good decisions on their behalf. They should also keep good records of how the power of attorney is used. So what we recommend is to have, an Excel spreadsheet if they can, with the date, what type of transaction they did, or what type of decision they made, and why they made it, and a line per type of decision. If they don't like Excel, they can use a notebook, but make sure to not lose the notebook because there could be an investigation by the public guardian and trustee if there is any report that they may have abused their authority. And it's always good to consider any trusted alternatives who can help them if the named attorney is no longer able, capable, or willing to assist them. And many of our clients don't have that luxury of having many, people who could help them, but it's still a good conversation to have with them. And there are always alternatives like the public guardian and trustee could assist, but there are limitations there too. So ideally, if the adult can pick someone who they trust, it's just better than hoping that the PGT will step in. So any questions about powers of attorney?
Yeah, so there's a question in the chat about an earlier point you'd made about when you die, clarifying, does the power of attorney end?
Yeah.
And if
Yes. The minute someone dies, the power of attorney ceases to be effective. And it's a huge misconception that so many of our clients have. They think that they have a power of attorney, so they don't need a will, or that, or vice versa.
Yeah, thank you for that clarification. And then if I can ask one question myself, I'd just be interested to know if an older adult perhaps suddenly has a stroke or something like that, and they weren't expecting any health issues or that sort of thing, and then they don't have a representation agreement and don't have a power of attorney, what happens in that case? Can one still be appointed or?
Um, so again, it depends on where they're at. Like, are they still able to communicate their wishes? It doesn't have to be orally. So we've gone to great lengths in trying to accommodate people and assess their capacity. So people who are deaf or hard of hearing, people who are no longer verbal. We've gone through different types of yes or no, and trying to go through so many questions to try to gauge if the person still has the capacity to understand their finances, understand their health when it comes to representation agreements. And if we find that they can still understand, who is near them, what type of healthcare decisions they may have to make. Do they know who they are? Do they know their family? Do they know try to understand where the capacity is at. If they have the capacity necessary to make that power of attorney, even if they have communication issues, we'll help them make one. Now, if we have strong doubts that they understand the full scope of what a representation agreement or a power of attorney can do, but they trust their spouse fully to make any decision necessary, then that's when representation agreement section 7 may be suitable. So it's limited in scope, but we can still do that. When they're beyond that, so they can't they don't seem to have the capacity necessary to make those decisions. They don't seem to really understand who's around them or what they can do. They don't really know what they have. Then it's usually too late. So they are substitute decision makers, depending on what it's for under various legislations. But oftentimes that's when an application in court, a committeeship application in court is needed. And you made a very important point there. You said someone who didn't expect anything to happen, how does a stroke? And most people don't expect to have, a stroke or a health issue, and that's why it's so important to think about that when you're well, because it gets to the point where it's too late. We work in palliative care as well, and like 3 weeks ago, I met someone who was in their late 80s with cancer. I won't go into too much detail, but I was called by the facility saying so and so wants to see you. We had a conversation, but then that person didn't feel ready to sign court yet. So I called the next day. I say, okay, let's try next week, and say, okay, I'm not too sure. I don't really feel ready yet. And then he passed away. So it was really sad because in that case, it was not necessarily that um, a power of attorney or representation agreement was needed, but it was too late for the will. And they wanted to benefit someone who would not have been a natural beneficiary under the law. Like they had many siblings, they had no family, so the siblings would have inherited first, but they wanted to benefit mostly one niece and maybe someone else, but they couldn't really decide the percentage. Anyway, the point is the same for incapacity planning. People really need to think about this when they're well, because it's so much more complicated to navigate the system when it's too late. And when it comes to committeeship applications, just so you know, it requires two medical affidavits from doctors. That's $5,000 per medical affidavit. So it's $10,000 just to get those two medical affidavits, plus legal fees if people are not eligible for services. So easily $15,000 for court application to appoint someone, which could have been easily avoided if they had a power of attorney and a representation agreement. We assist with those applications, but we don't have the ability to assist with them routinely because it's so expensive. And if the person who wants to be named committee, like guardian, the equivalent of a representative and attorney, does not have the money to do so, the Law Foundation may agree to cover those funds, but it can't do that, every week. So really, it's an enormous cost to the family or whoever is willing to take care of that person when nothing is in place. The public guardian trustee may be able to assist, but it's also lengthy. And in the meantime, they may incur expenses. So we've seen situations where children wanted to make an application in court to be committee of the person, committee of the estate, so be appointed in court to do whatever an attorney and representative would be able to do. And in the meantime, they were paying out of pocket their mom's rent, their mom's, food and expenses, even if mom had a fund that they couldn't access. Right. So it was putting them in a precarious situation. So everybody was in a precarious situation for the length of the application. And it took about 2 months.
Wow, thanks for sharing that additional detail. I didn't realize it was so very expensive.
Yeah, it's expensive and it's long. It takes so much time to get those affidavits and all the information on the application. Whereas an interview for a power of attorney and a representation agreement and a will is usually an hour and a half. And then we meet them usually 2 weeks to a month later, depending on how often we can, if they're local and then it's another hour. So in 2.5 hours, if you know what your assets, debts, and family members are, you can have that document done, or those documents done. And it avoids so many issues and conflicts. Anyway, any other questions? Sorry if I'm rambling here.
Nope, I don't think there's any other questions, but thank you for answering. I think that's really helpful to know that information.
Sure. Wow, we just see so many of those. It's like, well, I'm just waiting, and people wait until it's too late. Not always, but kudos to anyone who has a power of attorney or presentation agreement and a will. Joint ownership, I just wanted to briefly touch upon that because sometimes people say, well, I don't really need a power of attorney. I'm joint with my daughter or whoever. So a few issues with that. So it may be great. It may work really well if the only other person in your life is that child. But and they are responsible. But it can become an issue because if they have debts, these debts become your debts. It can be an issue because if they pass away and you also have, other children and you wanted to divide everything you have equally between your children, well, it won't be the case anymore because by making that person joint on your account, basically they became the survivor owner of the account and they get everything in that account and there's nothing left to share with the others. There are some exceptions to that. Some financial institutions can set up a joint bank account, so it does not include that right of survivorship, but not always. So I encourage people to talk to their financial institutions and see what's possible, but having in mind that their debts can become your debts and that it can have an effect on who can inherit from you. And when I say you, is like whoever is setting that up once you pass away. Because many people don't realize that. And they have, that joint bank account and everything they have is in on that account. But when they pass, like it all goes to that one person who's joint. So some food for thought. Yeah. Now I'll go over wills, and that's a document that most people are familiar with. So it contains instructions on what the adult wants done with their body and everything they own after their death. So it appoints an executor. So that's the person who's going to file the last taxes, take care of funeral expenses, talk to, the bank and the CRA and so forth. It's only effective after death. And just know that some assets cannot be divided in a will, like joint ownership. Joint property, life insurance, investment income cannot be divided in a will unless the beneficiary is the estate. If it's the estate, then it means that it goes through the will. But if there's a beneficiary named on an account, then that person will get everything, or it will be divided according to what the beneficiary clause states in that document. So for will, it's important to consider who will be a reliable executor and someone who can manage conflicts between beneficiaries and family members. There are so many conflicts after someone passes. There are conflicts about funerals. Should they have a ceremony? No, they would never have wanted a ceremony. Or did they want to be cremated? Maybe they can't afford to be buried anyway, but that's easier to discuss if it's in the will. What should be done with the ashes? We've seen disputes over ashes, and it's really sad, but it's so again much easier if it's in the will itself, so it doesn't leave room for interpretation. Who did they want to leave their assets to? And always, it's important to think about who would be an alternate beneficiary because unfortunately, people die. People move away from the country. So it's important to just have alternates for everyone named in the document. So again, it's important to choose someone they trust who can handle that requires duties and have a cool mind after the passing of that adult. Will they be able to handle taxes, the probate process, dealing with all the debts, the funeral arrangements, any conflicts between family members, or even if there's no conflict, just keeping everyone up to date all the time. That takes time. Someone who's good with details and record keeping And ideally, someone who's conveniently located or who can come to the adult or the deceased, the adult if they're near death or the deceased afterwards to, deal with all of this, including emptying the home. Or maybe it won't be emptied, but there will be some distribution. It's just easier if they are there in person. So when someone dies without a will, family members inherit. So first the spouse, then the children, um, and then the ascendants, if there's any left. So the parents, and we go to the siblings, and there's a long list. And the last entity that can collect whatever is left is the government of BC. It would be different if it was on reserve or First Nation lands reserved for First Nations people. It would be typically the band. Sorry, I don't know what's going on. So if there's no will, it's an administrator who steps into the shoes of what would have been an executor, but they're appointed in court. And they have to, it's a bit longer, it's a more complicated process because they have to notify anyone else who would be listed as having a higher order of priority. They need to see if anyone contests it, just to be the administrator. And if no one is available, the PGT, the public guardian trustee, may be appointed by the court, but it depends on the value of the estate as well. Sometimes it's not worth it for them. And some estates don't need to be probated. So we see cases where people have, it depends on the financial institution, but typically it can be 5,000 or under 30,000. The bank may be satisfied by seeing a will and to release the funds to the executor or the beneficiary. Depends on how complex it's set up. But for small estates, the probate application may not be needed. So it's another advantage of having a will, even for small estates, people who don't have a lot of money. It just simplifies that process a lot, because when there's not a lot of money, but then the financial institution requires someone to go to court to be appointed administrator, it's just an additional hurdle, and some people may not want to even bother, which is or it might be because it's too much work and they don't have it in them, and it can be having a will can be a way to preempt all of those issues and make it simpler for their beneficiaries. Storage of will. So there's what's called the wills notice, the wills registry, but it doesn't keep a copy of any will. So the wills notice registry, it's called the wills registry, to me it should be called the wills notice registry, just keeps track of what's on that page. I mean, now there's also the electronic version, but it's harder to make a screenshot of it because it's 5-6 screens. It's the same information on the paper form. So basically it states when the will was made, where it's going to be stored, and it's signed by the will maker. And that makes the probate application a lot easier. So when someone, it's not required, it's not mandatory to have a wills notice filed with vital statistics, but it's only $17. And when that's done, it's a lot easier to get probate. So probate is the process to have the court confirm that the will is valid, and so it can be used by the banks and um, so many agencies to follow whatever is listed on the will. So the the probate registry will require the named executor to provide the will and to do a wills notice search. So the executor will need to go to the registry and ask for a printout of the wills notice. If the will's notice shows that the date of the will was, let's say, February 17, 2026, and they present a will to the probate registry dated February 17, 2026, and they will ask, where did you find this will? Well, I had it. I was the keeper of the will, or I found it at my mom's house. And the present location of the will on that will's notice says that it's, at the location where the executor had access. um, then it's going to make that process a lot simpler. Say, okay, the probate registry will likely be satisfied that that's the right will. Similarly, can protect will makers from having their previous wills used against them, because they say that the last will was done on February 17, 2026. If someone presents a will that was executed in 2020 or 1994, while the probate registry will say, well, that's not right because the vital statistics form shows that the last will was done in 2026. So again, it is not mandatory, but it's a way to protect the will and to make the life of the executor a bit easier. Just to recap, when the adult is alive, powers of attorney, representation agreements, advance directives, and joint ownership work to assist with decision making. But once that person dies, the power of attorney and your representation agreement cease to be effective. And that's when the will comes into effect. It's when any property that's owned jointly may pass to the survivor, and when any beneficiary appointed under life insurance clause or an investment like a TFSA clause will receive whatever is on that account. It could be split. So that's what we discussed earlier. It was, Laura's question. So yeah, it can be a committee of the estates and so forth. So yeah, so people should think about who can be executor, representative, or attorney. It could be the same person for all three, or it could be different people. It's good to think about who will be good with money as opposed to healthcare decisions. And maybe the person you're thinking of or they're thinking of would be good with everything, but maybe they have a good friend who's an accountant who are nearly retired accountant who's willing to be their attorney, and that would be a great fit. And they have a sister or a cousin who's a nurse, and they would like that for that person to be their representative. And if that person is a bit, older themselves, maybe they could be the primary representative, and a child would be the alternate representative. That would be some of the discussions we would have with our clients. When people come to an appointment and prepare those documents, they really need to have the full legal names, including middle names, of anyone they name in their document. And that includes grandchildren for wills. So the addresses, if there's any First Nation person, their status card with their status number, and the name sometimes is different from the one on their BCID. And that might be a clerical issue, but I see that all the time. Yeah, like Joe and Joseph, or people who have somewhat different name, or the middle name is switched with the first name. So we would put, also known as, to make sure that there's no issue with the bank or Indigenous Service Canada and so forth. So where will the legal documents be stored? Some people put that in their fridge. What happens if there's a power outage? Can the person named access those documents? Will they know where to look? Some lawyers keep those documents. They keep the originals or certified copies. And that's great, but does the representative or beneficiary executor know who that is? And when they think about who they should contact for help, it's good to look at professionals who handle those tasks routinely. Not all personal injury lawyers will be cognizant, familiar with wills. So just to make sure that they use the services of someone who's familiar with the documents involved, and to be very clear about how much will that cost. And if it's a simple estate, if it's maybe a notary can do it for cheaper. If it's more complex, then a lawyer might be required. It's not on this slide, should change that, but to talk about anyone who has disabilities, because a beneficiary who has a disability, if they receive, for example, more than $100,000, it may affect their benefits and work against them. And so a trust should be set up. But again, it depends on the personal circumstances of the client, but it's so important to disclose those issues to the professional they talk to, so they can be a discussion about how that should be set up. So some resources, the province of BC has some good resources on incapacity planning. However, the representation agreement section 7 is missing some forms, so don't use that. People's Law School has great information for non-lawyers who just want to understand how probate works, how powers of attorney works. They work with lawyers. They're fantastic. NIDUS also has good information. They have a registry, an online registry for all of those documents as well. It has a cost, but just so you know, it's a good resource. Planning Institute of BC specializes in people with disabilities, but there's also Coast Mental Health. I should mention that. I'll give that to you with the slides like this. All is listed on the slides. So are there any questions? And I should thank our funders. So the province of BC, the Ministry of Health mainly, funds our Seniors Abuse and Information Line and the Public Education and Outreach Program. And the Law Foundation of BC funds our legal programs with some top-up funding from the City of Vancouver and now historically Vancity for our tenants, clients.
Well, thank you very much for that wonderful presentation. I know we're a little bit over time, but there was one more question. If you're able to just clarify about if a representation agreement is needed as well as enduring power of attorney.
Yes, that's the golden standard. So a representation agreement, well, for people who have full capacity, a representation agreement, Section 9 will deal with all of the healthcare decisions without any limitation and work in long-term care and would be only for healthcare and personal care. While the power of attorney would deal with all the finances of the adult and legal decisions. Sometimes people no longer have the requisite capacity to sign those documents, in which case a representation agreement section 7 may work, but it doesn't have the same scope. It's much more limited. So that's why I say the golden rule is to have a representation agreement section 9 for all the healthcare and personal care decisions, and a power of attorney for all the legal and financial decisions.
Yeah, thank you very much for that clarification. And there was a comment in the chat from somebody talking about the challenges that they had encountered when their mother-in-law didn't have those documents, and then they were trying to get an affidavit and they had to pay out of pocket for 3 years. So it sounds like those documents, of course, are so vital to have. And as you mentioned, have them in advance. So I think hopefully we'll all be able to take away a lot of tips like that. I know for myself, I've learned a lot about wills, and then things that I should be maybe mentioning to my parents about having that representation agreement planned in advance. So thank you very much. This has been really informative.
My pleasure. Thank you for inviting me.
And all right. Well, thank you. And so we'll be sharing out the slides and the recording afterwards. So you'll be able to have all of that information and the links for everyone who's joined. So thank you very much. Oh, and there is one last question in the Q&A. And it's, what if someone literally has no one to ask to be executor of their will?
Great. So the public guardian trustee can be named, but hello?
Oh, yeah, we can still
Am I
hear you.
still with you? Okay,
Yeah.
okay. So the public guardian and trustee can be named, but usually they want to have a heads up and review the will to see if there's any issue, any confusion before they accept the appointment. And if they accept the appointment, then they keep the original will. There are also corporate executors, but that's different. And if the PGT is named, they cannot be any alternates. It's just them.
Yeah, thank you for letting us
Great
slip in
question.
that last question.
Of course.
All right. Well, I hope everyone has a really wonderful day, and thank you so much, Marie Noel.
Okay, thank you. Bye.
Right. Take care, everyone.